G'day everyone, can you hear me up the back? Yes, excellent, excellent. Thanks so much for joining us tonight here at Politics in the Pub. It's so great to see so many faces out there. Thanks for your interest in our event tonight. My name's Ebony Bennett. I'm Deputy Director at the Australia Institute, and I'm a last-minute sub-in for Richard Dennis, who couldn't make it tonight, our Executive Director. So you're stuck with the consolation prize of me tonight, I'm afraid. I have much less economic expertise, but quite a bit more hair. So hopefully that will compensate. It's great to see how many people are out here tonight. I did want to begin. I know the news is pretty awful today, and in my opinion, the news from the weekend was pretty terrible as well. And I do want to begin by acknowledging the traditional owners of Canberra, the Ngunnawal and Ngambri people, and pay my respects to elders past and present. I want to acknowledge the huge amount of work that went into the Yes campaign, which, as we now know from the referendum results, was supported by a majority of Indigenous Australians, particularly if you look at the remote booths in the Northern Territory and Queensland, where we had larger proportions of Aboriginal citizens in those electorates and booths. The Australia Institute supported the Voice to Parliament and the referendum, and you know, there's years of hard work that I know went into that effort from Indigenous leaders over just so much of the last few years. Huge efforts, and I'm sure equally huge efforts from the No campaign, but I know it was extremely bruising for people involved in that, and I just wanted to acknowledge, I guess, all the effort and how disappointing that even this modest request for recognition couldn't get up in Australia. Obviously, the that the no vote does nothing to close the gap between outcomes in Indigenous and non-Indigenous Australians. And as Bernard Keane wrote this week, means our constitution continues with the fiction of terra nullius, essentially. So one thing we know is that the campaign was characterised by a lot of lies and misinformation and disinformation. And keep an eye out tomorrow. The Australia Institute's got some new research coming out about the impact of that in the campaign and truth in political advertising. We do love hosting Politics in the Pub and love to see you all here this evening, but it's not free to hold, and we do have a donation tap and go up at the bar where you can grab yourself a drink, and please chip in if you can. It does help us to continue to run events like this that we know you all love. So the Australia Institute has been looking into the issue of whistleblower protections for a long time, and we all know that by exposing human rights abuses, government wrongdoing and corporate misconduct, that whistleblowers are really brave and courageous, and they make Australia a better place. Yet too often in this country, whistleblowers are prosecuted rather than supported. And tonight we've got the privilege of hearing from a very distinguished panel of experts. In recent years, we've obviously seen the prosecution of whistleblowers and journalists, raids on journalists and media organisations, and a number of prosecutions of people like David McBride, Richard Boyle, and others serve as very poignant reminders that the challenges are huge that face whistleblowers who are trying to blow the whistle on misconduct and wrongdoing. So tonight we're honoured to have Kieran Pender, a senior lawyer at the Human Rights Law Centre, who leads the Whistleblower project aimed at protecting and empowering Australian whistleblowers. We're also privileged to have Professor Peter Greste, an award-winning journalist and author. You might have seen him at the press club earlier this week and caught him there. He's not only reported on some of the world's most challenging regions, but obviously also experienced the harrowing reality of press freedom limitations in his own life, to put it lightly. I'm sure we'll touch on that this evening, and his advocacy for press freedom and for journalists has been immense in the past few years. Lastly, Rawan Arraf is the Executive Director of the Australian Centre for International Justice, an independent not-for-profit and specialist legal centre that works to develop Australia's capacity to investigate and prosecute atrocity crimes. So we're really at a critical juncture here, and these guys have been in Canberra all week doing all sorts of exciting things. But I might kick off with you, Kieran. Can you just tell us a little bit about the Whistleblower project and why the Human Rights Law Centre saw a need for such an intervention?
Sure, and thanks everyone. Also acknowledge that we're on stolen Aboriginal land of the Ngunnawal and Ngambri people, and thanks to all of you for coming out tonight. Some of the discussion that will follow is probably a bit depressing. It's not a good time in Australia to be a whistleblower, and that has really significant negative implications for all of us. But I hope we can also offer some optimism about some of the prospects for positive change that might lead to a better situation for those who play a vital democratic role in Australia and thereby make Australia a better place. We know that whistleblowers are suffering. We know that whistleblowers are so important to democracy, and that's the paradox. Why do these people who help expose wrongdoing also suffer so much? If we think about the things we know, because brave people speak up, some of the scandals of the past decade that we know that led to royal commissions, front pages, inquiries and change and accountability, we only knew about them because individuals, whether inside government or inside corporations, spoke up. Equally, what don't we know? Because right now people aren't speaking up. We have laws on paper that say that if you are a whistleblower, you're protected, you're not punished. Those laws aren't working. The Human Rights Law Centre recently reviewed every single whistleblowing case in Australia ever to go to judgment and found under the two primary federal laws, not a single successful case. In 30 years, we've had across the states and territories and a federal level, we've had over 22 different whistleblowing laws. There's only been one case of a whistleblower being compensated for suffering as a result of speaking up. That person got $5,000, which I'm sure was a real pat on the back. So the laws aren't working. The research shows us both anecdotally and empirically. Griffith University has done a fantastic amount of research in this area that shows that people who speak up at work suffer as a result. We've got cases of whistleblowers being sued by their employers, and then quite prominently right now, and I'm sure we'll talk more about it, we have whistleblowers on trial for telling the truth. All of that led to the reality and the recognition from the Human Rights Law Centre that civil society needed to be doing more to protect whistleblowers. It's been really fantastic in the last few years to see a groundswell of support in the community and in civil society advocating for stronger whistleblower protections, advocating for an end to the prosecution of whistleblowers. But what we saw as the missing piece of the puzzle was practical legal support for whistleblowers. In other jurisdictions where whistleblowing laws have worked, not just on paper, but in practice, in places like the United States, there are civil society groups doing the heavy lifting of assisting whistleblowers, providing legal advice and legal representation. And so that was why a couple of months ago, the Human Rights Law Centre was really pleased to offer this, to launch this service where we will, and already are, and have been inundated with interest from people who need support and are beginning to take on cases and hopefully begin to turn these laws that on paper look pretty good, but just entirely failing in practice. We hope that that will make a really significant ongoing contribution to integrity in Australia, because the thing about whistleblowers is they're going up against the might of a company, they're going up against the might of the government. They need people in their corner, and that's what we're hoping to offer. The advice, the expertise that we bring, not only our legal expertise, our media expertise, our political expertise, to try and hold wrongdoers to account and protect those who are speaking up.
Thanks. I'll come to you next, Peter. Obviously, you've had an intimate experience of having been deprived of your liberty, being imprisoned for doing your job as a journalist. I wonder if you can reflect for us on what that experience has brought home to you about the importance here of being on the lookout for press freedom in Australia.
So that experience, for those of you who don't know, well, okay, maybe there aren't. Come on, there may be one or two in here. I was arrested on terrorism charges in Egypt back in 2013, and I spent 400 days in prison before before a truly global campaign of pressure was able to release me, and we were able to get my two colleagues who were also arrested out some months later. That experience really made me reflect on what had happened to us at a kind of more abstract level. And the way in which a government had taken loosely framed national security legislation, which really, the kind of rhetoric around national security really swept the world after 9/11, really framed so much of the political debate and created a very powerful political incentive for governments to pass all sorts of loosely framed national security laws that in all sorts of ways intruded on people's civil liberties. And the more I looked at it, the more I realized that those political pressures weren't unique to Egypt. They weren't unique to draconian or authoritarian societies. Places like Australia were vulnerable to those too. And I and my colleagues started to look at the legislation here, and we realized that, well, Australia are world leaders when it comes to national security legislation. Since 9/11, successive Australian governments of all stripes have passed around 100 national security laws. It is an absolutely phenomenal number. And in fact, a Canadian researcher, Kent Roach, back in 2010 described it as hyper legislation. We were passing laws that quickly, and that was when we'd only passed 50. Yes. Now, the thing about Australia, as I'm sure most people in this room know or would be aware, we don't have any kind of codified human rights, code of human rights or human rights bill anywhere in our constitution or in our law. And because we don't have that, there's no benchmark that forces Parliament to consider human rights, much less freedom of speech or freedom of the press, and factor that into these laws. And so what we've seen, and I and my colleagues published a white paper on this a few years ago, we said that the legislation had criminalized what would have been previously considered to be perfectly legitimate journalistic investigation. We said that the laws had exposed journalists' data to overbearing investigation. We said that journalist sources, whistleblowers, were vulnerable to prosecution. We published that white paper 2 weeks before the AFP raids, and a lot of people, when they saw, not a lot, but a few people thought I think suspected we were being a bit tinfoil hatted about it. We were being a little bit dramatic. Australia isn't that bad. We don't go after journalists. But the fact is that the AFP raids vindicated everything that we said. Crucially, and I think Kieran made a really important point here, it's true that we're not seeing journalists being routinely locked up. The two cases, the two whistleblower cases, David McBride and Richard Boyle, are two very prominent examples of the problem that we're having. But in the same way we don't know of the number of whistles that aren't being blown because of this, we can't quantify the number of public interest stories that aren't published because of the way the law works. We do know unequivocally, because of research that my colleagues at the University of Queensland and elsewhere have been doing, that it is indisputably having a chilling effect. A lot of journalists we've spoken to have said they have had to shut down stories themselves, or they've had sources withdraw because of the threat that the law poses, because of the risks of being exposed and of the consequences of exposure. And this is why we think it's really important. Australia, the New York Times, after the AFP raids, said Australia may well be the world's most secretive democracy. And any journalists who worth their salt will agree with that. I don't look it, but it's indisputably the case.
Yeah, and even more recently, we've seen just in the last few weeks, police kind of demand that ABC Four Corners hand over footage. So it's still very much a live issue.
It is very much a live issue, and I think we need to keep talking about it. And this is also why, just very quickly, why I'm here as a part of this campaign, Kieran's campaign to support whistleblowers, because we very much see whistleblower protections as a media freedom issue. Journalists have to be able to have access to those sources, and where appropriate, they've got to be able to make sure that they protect those sources as well. What we see with David McBride and Richard Boyle isn't just going to have a chilling effect on classic whistleblowers, but also on public interest journalism.
Rawan, I'll come to you next. You've been working with whistleblowers working in the area of war crimes and atrocities. Can you tell us a little bit about that work and some of those whistleblowers?
Unfortunately, we're not working with whistleblowers. What we're working with is a process that's been set up because of people like David McBride and courageous individuals within the Special Forces who came forward and went to the media to expose the very wrongdoing, the serious crimes that has been conducted in our name. So we're monitoring Australia's response to the Burton report. Of course, David McBride, one of the whistleblowers who came forward and provided material that the ABC published under the Afghan files in 2017, he came after a very long process. He exhausted all internal mechanisms to expose that wrongdoing and seek accountability. And nothing was being done. So he came forward and brought those stories. And I think what's important to realize is that this is something that Afghans communities in Uruzgan and Kandahar, primarily the provinces where Australian forces were stationed and where the crimes were being committed in our name, had been knocking on the doors of the ADF, the Afghanistan Human Rights Independent Commission, with the media as well, trying to seek accountability or just to find the mere truth about what happened to their family members. The Burton report even acknowledged that those Afghan families and communities, their complaints were dismissed, and there's a racializing element, an Islamophobic element. They were dismissed by internal inquiries because they were said that the Afghans only wanted to seek compensation, that they were just propagating Taliban propaganda, and all that sort of thing. So it's because of people like David McBride and the others in the Special Forces who came forward and provided those stories to the media that we were able to have the processes, those inquiries that led to the Burton inquiry that set up that process for where we're seeing a criminal justice process now, in addition to other administrative reviews inside defence to look at the culture of silence and other recommendations that the Burton report included when it was handed down 3 years ago. So I think it's a real injustice, and it talks a little bit about the priorities of the Australian government. Of course, we have set up this criminal justice process. What I mean by that is we have the Australian government established a special office of the Special Investigator, an ad hoc investigative office that's working with the Australian Federal Police to investigate some of the cases and even others that the Burton inquiry didn't look at. But what we're having is a criminal justice process that could take a very, very long time. But one of the people who made that process happen, being prosecuted for exposing the truth. And I think that sets a real chilling effect, as we've been saying in the last few days. But also, what does that say about the Australian government's priority? We still haven't compensated or provided other forms of redress and reparations to the Afghan victims and their families for the very serious wrongdoing, these allegations of war crimes, in which the Burton report actually said we don't need to wait for the outcome of a criminal proceedings in any one of those cases to provide that means of compensation. But we should do it because it's the right thing to do and it should be done. And in many cases, it's the passage of time of over 10 years in some of these cases where family members were killed and injured as a result, property destroyed, etc. So I think that's why we're concerned about what are the optics around prosecuting David McBride, and what does it say to other whistleblowers in Australia, but and particularly within defence and other national security, the national security, I guess, what would we call it, complex. I'm not sure what the proper terminology is. But what does that say to others who would want to expose wrongdoing in a very serious area where we have international crimes being committed in our name, not being able to come forward because they could be prosecuted? There was a point made by Andrew Wilkie this morning when we had a parliamentary briefing with him, which I thought was very, very pertinent. We should be proud where he suggested that what about in cases around the world? In the UK, for example, I think what the UK is struggling with at the moment is the code of silence, which Australian special forces, those brave people like David McBride and others who broke that code of silence. In the UK, they're having a problem because no one is able to break through that code of silence. So if they're seeing people in Australia being prosecuted for that, would people in the UK come out and try and expose wrongdoing that UK forces were also involved in? But I think one of the points I wanted to make as well is that, you know, we should be proud of the process that Australia has set up, in the sense that we are the only country where Western forces involved in the military adventure in Afghanistan are actually having a reckoning with the allegations of war crimes. We're actually trying to amend, trying to repair the harm that was done in our name. But to do that, firstly, by prosecuting somebody who tried to expose the truth, is a real injustice.
Yeah, it certainly sends the completely wrong signal when what we want is, you know, first of all, for those crimes not to have ever happened, and to discourage that kind of a culture within defence. But if it is going wrong, you know, we want to know about it and stop it. So, Kieran, that brings me back to what reforms are actually required here to improve protections for whistleblowers.
A lot. The government has a lot of work to do. As Rawan mentioned, Peter, Rawan and I and some of our colleagues have been at Parliament all week trying to engage with the government, with the crossbench, with the opposition to strengthen whistleblowing laws and then to put an end to these ongoing prosecutions. So, as has been mentioned, there's currently 2 people on trial in Australia for telling the truth: David McBride, the war crimes whistleblower, Richard Boyle, who exposed wrongdoing at the tax office. Adele Ferguson did a really powerful story on 7:30 a few weeks ago on Richard, which I'd really commend to you if you haven't already seen it. We've been calling for 3 things in our advocacy at Parliament this week. We need to drop these prosecutions because there's no public interest in prosecuting whistleblowers. We need to fix the law. There's a lot of reform that's needed. And then we need to set up an independent whistleblower protection authority to oversee and enforce these laws. The laws aren't working in practice because we don't have an independent enforcement body. We don't have an independent body to support whistleblowers. Increasingly in other countries, we're seeing these bodies being set up. In the US, there's a long history of similar bodies being really effective. In Slovakia, in Ireland, in the Netherlands, in Finland, and so on. Australia's once led the world in protecting whistleblowers. The concept of whistleblower protections emerged in the US in the 1970s. In the 1980s, we had the Fitzgerald inquiry into police and political misconduct in Queensland. Tony Fitzgerald recommended whistleblowing law in Queensland in the early 1990s. They enacted Australia's first whistleblowing law. At that time, Queensland was second only to the United States. So Australia once had a proud history of protecting whistleblowers, but in the successive decades, we've fallen behind. And in the past 10 years, under the coalition government, we had a war on whistleblowers. We saw, as we know, the raids on the media, the prosecutions, and so on. The Labor government has done a lot of good work on transparency since coming to power. We've really applauded that. They discontinued the prosecution of Bernard Collaery, which is a really significant step that I know many people in Canberra called for, and I know that many people rallied outside the courts on successive occasions, calling on the injustice of that and calling for it to end. Government has done some whistleblowing reform, initial technical reforms, reviewing secrecy laws, reviewing surveillance laws, and so on. So the government is talking a good game and it's beginning to move forward, but there's a lot that needs to be done. And the problem is, while we have these 2 prosecutions ongoing, the credibility to deliver that reform, deliver the institutional change we need, the creation of a whistleblowing body, and so on, is totally missing. If, as we said, David McBride goes on trial just over there in the ACT Supreme Court in 4 weeks' time, the first person on trial in relation to war crimes in Afghanistan, the whistleblower, not an alleged war criminal. As we've been saying to Labor MPs and senators all day today and yesterday, what credibility will the Labor government have to deliver whistleblower protection reforms if they oversee a whistleblower going to jail? Do we want to be a country that locks up whistleblowers? I hope the answer to that is no. There are two people in Australia who can stop these prosecutions: the Attorney General, Mark Dreyfus, and long day, Mark Dreyfus, and the Commonwealth Director of Public Prosecutions. One of them in the next 4 weeks needs to act. Otherwise, a whistleblower goes on trial. And it's all related. So we see this as all really interlinked to the reform agenda, to the establishment of a Whistleblower Protection Authority, because whatever the laws, whatever the institutional change, if we're still locking up whistleblowers, that will be a really bad sign. The government did it once. They dropped the Cleary case. That was the right thing to do. As we said at the time, it was a case of 1 down, 2 to go. And yet, after they dropped that case, they haven't taken any action in relation to these other 2 whistleblowers. So it's really exciting that the government's committed to significant whistleblowing reform in the months ahead. They've promised significant reform to public sector whistleblowing. We're in Canberra. I know many of you, probably public servants, the Public Interest Disclosure Act is a mess. A federal court judge described it as basically incomprehensible, even to lawyers. Even myself, I struggle to make sense of it. The government's committed to significant reform of that. Said this year, realistically, we're probably looking at next year now. They've promised a discussion paper on whether we need a Whistleblower Protection Authority. That's a really significant missing piece of the puzzle. The establishment of the National Anti-Corruption Commission, unfortunately, was a missed opportunity there. The crossbench National Anti-Corruption Commission bill that Labor said it supported under the last government, that had a whistleblowing body built into it. So Helen Haynes was at this briefing we had this morning. That was her idea. And yet that bit came out of Labor's bill that became law. So we see that as NAC 2.0, the missing piece of the NAC puzzle. Government's promised a discussion paper on that this year. Our view is we don't need to discuss it. We need to do it, but we're happy to discuss it if that's what they want to do. There's reform of private sector whistleblowing reform next year due. That's all great. It's all exciting. But these 2 prosecutions hang over that like a dark cloud.
There was quite a few things missing from that Labor bill for the National Anti-Corruption Commission in the end, public hearings among them. Peter, I want to come back to you. You've talked about whistleblower protection being an incredibly important part of freedom of the press, but I wonder if you can touch on what reforms you think are needed in order to protect press freedom in Australia.
Sure. So there's a lot of talk about patches to national security legislation. That's all well and good, and we applaud that work. The Attorney General is also looking at reviewing a lot of the security legislation to see how it protects, see if there are protections that they can put in place for journalists and media freedom. As I mentioned earlier, the reason we've got this problem in the first place is because we don't have any institutional or constitutional protection for media freedom. Given the experience of last weekend, getting journalists protected in the Constitution, I don't see that like that's going to happen, right? So the next best thing is a piece of legislation that does much the same thing, that writes the principle of media freedom into our laws. There's the Human Rights Act here in the ACT, another one in Queensland and Victoria, and those acts do 3 things fairly simply. First of all, they say that Parliament must always consider human rights when they're passing new legislation. They say that the courts must interpret existing legislation in ways that are consistent with human rights and privilege human rights, and that civil servants must act in ways that support human rights. If we replace the words human rights with media freedom, then I think we are close to something that does the job that we are trying to do. We are not saying that media freedom must trump everything all of the time, that journalists should be able to publish whatever they want, whenever they want. What we are saying is that there needs to be an opportunity, a positive obligation to consider media freedom at every stage of the process whenever we're dealing with journalists. We are also, because we know that a Media Freedom Act is a complicated beast, my colleagues at the Alliance for Journalist Freedom have actually written a draft. It's not quite ready yet. There's still some tweaks that we need to make. We've been working with a very talented retired legislative drafter to do it. So we know that, and some lawyers from Sydney, we know that what we've got is solid. What we are doing is building in a legal presumption in favour of publication. And we're saying that We're not saying that journalists must have the right to publish. What we are saying is that if there is an overriding reason or public interest in continuing a prosecution and investigating, then that's fine. You can do that. But you've got to make it clear that there is a compelling public interest in an investigation and a prosecution that trumps the public interest in transparency and accountability, and that trumps press freedom. I think we can do it. It's going to be a challenge to get it through. This is a long-running project that we have, and there are some other elements to this that we can talk about a little bit later. But essentially, that I think is a really important solution that would fundamentally change the nature of the relationship between government and the media.
Yeah, as you say, there's no existing protections, but as we all know, journalism is it's a public good. It's an incredibly important part of a healthy democracy and really important for public accountability. And Rawan, public accountability is or the implications for accountability in general is what I wanted to come to you next on. What are the implications for Australia here and overseas of the way that we're approaching atrocities and war crimes and these investigations?
Well, I think it sends absolutely the wrong message. I actually don't even think people abroad know yet about the prosecution of David McBride. I think, at least in the space that we're working on, there's a lot of fanfare around the fact that Australia has set up this process, as I said before. But I think once the news hits abroad about the fact that McBride is being prosecuted, I think shit's probably going to hit the fan about the real positive reception that Australia got.
I think it's worth. Sorry, I'm just going to put on my journalist cap here because I know the images of David McBride being hauled into court and possibly being dragged off into prison are going to go everywhere. They'll be in the front pages of every newspaper in this country at the time when it happens, and a lot of news organizations around the world are going to pick those up. They will stick in people's minds and they will dominate and they will completely swamp anything else, any kind of speeches that politicians might be doing, any legislative changes. That's all going to disappear. It's those images of McBride in court and in prison that will set the tone and make it very clear where Australia stands on this.
And I think one point I wanted to mention, just because I remembered Kieran mentioned the two people who have the power, at least, to intervene in David McBride's case. Just to backtrack a bit, contextualize my answer, and what I'm going to say is, following the defamation trial of Ben Roberts-Smith, it became apparent that the Australian Federal Police had bungled, because they had carriage of at least, I think, 6 incidents. So Ben Roberts-Smith is involved in at least 6 incidents of serious wrongdoing that amount to war crimes. 3 of those incidents, including the most famous one, Ali Jan, the farmer who was kicked off a cliff, have been bungled to the extent that it's possible that charges might not be brought in those cases. So he could get off scot-free in those incidents. What's happened is now there's a task force with the AFP and the OSI that are looking into this. Thankfully, the federal court just said that they can have access to the evidence, some of the closed evidence in the defamation trial. But what that story exposed about the AFP's bungling of some of those, investigating some of those incidents, is that the Commonwealth Director of Public Prosecution sat on a brief for 2 years, that the AFP went to the CDPP and said, okay, here's the brief for Ben Roberts-Smith. Can you do, what do you think? Because they, part of the process is they brief them and then the CDPP advises, we need more evidence on this, go chase that. Oh, yeah, sure, let's take this for charges. They sat on it for 2 years. But at the same time, they were gangbusters on trying to get David McBride prosecuted. So I think that is a real injustice and speaks volumes about the priorities of the CDPP, at least in this case. So the implications are, we already had failings of institutions since 2005, since the time the Afghans were knocking on the door of the ADF trying to seek information about what happened to their loved ones. And failure of institutions inside defence, failure in the AFP when David McBride tried to go to the AFP, I believe, we had inquiry after inquiry and finally a process that's been set up. So there's serious issues about the impacts of accountability here. I know now we're at a process where, yes, it's going forward and we have to be positive about it and obviously monitor it, ensure that it's up to it meets international standards, that victims are allowed to participate in the process in a meaningful way. So there are a lot of implications, but I think the serious one, at least pressing to us as Australians now, is that one of the persons who's exposed what's going on or what went on is being prosecuted. And I think maybe, Kieran, we need to talk about how we maybe bring the international element, the story internationally before to try and bring the pressure on that front too to the government.
Yeah, well, that sounds like an important part of getting some well-needed spotlight shone on this issue internationally. I am going to go to questions from the audience next, but I wonder if we might have a round of applause for our panellists to begin with. So if you do have a question, we've got a microphone just down the front here. I will encourage people to put it in the form of a question and not a statement or a speech. We'll get to as many as we possibly can. And if you could just introduce yourself before you say your question. Thank you.
Hi, I'm Patty. The question begs itself. It seems bloomin' obvious that this should be dropped. What's the motivation for not dropping it?
Might throw to you first on that one, Kieran.
The Attorney General has said, so the Attorney General's power to intervene in prosecutions is rarely exercised. We have an independent prosecutorial process in Australia. We have a Commonwealth Director of Public Prosecutions. The Attorney General has said he'll only exercise his power to intervene in exceptional and unusual circumstances, and that these cases don't meet that threshold. To that, we say a couple of things. The first is that language is not in the Act. There is no exceptional circumstances test in the law. The discretion is the Attorney General's, and that reflects his ultimate political accountability to Parliament and to all of us as voters for his decision to intervene. The second thing is we don't currently have a Commonwealth Director of Public Prosecutions. The last one was appointed to the New South Wales Supreme Court 12 months ago. It's extremely unlikely the person acting in that role is going to make such a consequential decision. That means that really there's only one person in Australia that can make this decision, and there's 4 weeks on the clock, and we've called on the attorney to act. We really hope he listens between now and the 13th of November. But I think, to answer your question more substantively, when the attorney did the right thing by dropping the Cleary case. I think there was some resistance to that. Of course, making these decisions in a case like McBride, there are defence interests. Some of our foreign partners are interested in this case. There is no doubt resistance to dropping the case. In the Boyle case, the tax office is very influential. They don't like what Richard Boyle did in exposing wrongdoing at the tax office. So no doubt there are institutional barriers to the attorney acting, but he has to do the right thing because there's no public interest in prosecuting whistleblowers. It's really as simple as that.
Next question.
Hi, I'm Pamela. Thanks to all of you, and especially for all of you taking a stand for David McBride, which many of us have been doing for months, if not years. This national security laws thing, I mean, it's kind of undercover. Australians are not paying attention. That what you said, Peter, that, you know, this is the most secretive so-called democracy, perhaps of all. And it just goes on and on and on. And that means it's going to undercut all of everybody's rights. So what can be done or is being done or should be done to roll any of those back or to expose what's going on?
Peter, do you want to take that one?
Well, let me preface this by saying I'm not a lawyer. It's very difficult for me to come up with very specific steps that we could take. I do think the lack of, as I said, I think it's very clear, the lack of any clear human rights charter anywhere in Australian constitution or in law is a real problem. It means that we just don't have to address those issues. We're not compelled to address them. In Europe, the European Charter of Human Rights gives both politicians and activists an opportunity. It gives them a benchmark to say, no, these are the rules. These are the limits of where the legislation can go. We need you've overstepped those marks. You've overstepped those boundaries. You need to roll back and place protections that defend these things. In Australia, because we don't have that, there is no opportunity to make those arguments. I also think, that politically in Australia, the opposition, for a lot of this period, Labor was in opposition, and I think they never really pushed back on national security issues in the way that a lot of people might have hoped and expected, because they feel vulnerable on national security. They don't want to be wedged on it. News Corp has always gone after the Labor Party whenever they've looked soft or weak on national security, and I think that's created the real vacancy in that space, in that political space. I think that's why we're in the situation we're at right now. We all know it's almost impossible. I mean, there have been numerous attempts to get a Bill of Rights introduced into the Constitution. Again, given the experience of last weekend, that's just not a realistic prospect anytime soon. So that's why we're taking the approach that we are. I know that our approach only deals with a very narrow slice of the problem. That's really because obviously we've got a particular interest in protecting media freedom, and because we think that that slice is also achievable. If we can do that, maybe that also might open up opportunities for other slices.
Thank you.
I might just add on to that as well. I thought the point about the secrecy in government has been brought to the fore quite a bit over the last couple of years with, the Prime Minister secretly appointing himself to half the cabinet might be a good example. But one thing I know the Australia Institute has looked at in our research is looking to other democracies and how they deal with I guess the intelligence agencies and oversight over them. And if you look at how the United States Congress and standing committees over there can inquire into the operations of intelligence agencies and national security bodies, they've got a lot more leeway than certainly we extend to our parliament. So that's something to look at. And just a personal idea might be an audit of all the national security laws we've passed over the last decade.
Can I just, sorry,
No.
I was just going to say there's a little story, not a little story, but you might recall the data retention legislation from a few years ago. George Brandis, the data retention legislation says that telcos have to hold on to Australians' metadata for at least 2 years and give access to a number of intelligence and security agencies. The metadata isn't the contents of your communication, it's just the time that you made it, sent an email, who you sent it to, where you were when you sent it, those sorts of details. But it is incredibly rich data when you cross-check everything. Unbelievable, you can tell pretty much everything you need to know without actually having to open up the contents of those emails. Anyway, George Brandis said that this is important for Australians because it allows them to deal with serious crimes, drug smuggling, people smuggling, narcotics, weapons, all of that sort of stuff, serious crime. A few years ago, and the reason I mention this was there was similar legislation in Europe. The Europeans put really serious barriers around this because of the charter that they had, that made it very, very difficult for the authorities to make random requests for people's data without breaching privacy provisions. Here in Australia, a few years ago, there was an inquiry into the effectiveness of that bill. The Telecommunications Alliance, which is a group of telcos, did some sums, they totted up, and they said how many requests for metadata had been made in one 12-month period. Someone give me a number of how many sounds like a lot. 1,000? 10,000? Keep going. 350,000. That's more than 1,000 requests for metadata every single day. Now, admittedly, Some of those would have been duplicates, but we know from the inquiry that local councils were using metadata to investigate whose dog had left a dump on the footpath. We know that organisations like the TAB, that the RSPCA and so on were using metadata. This is not for serious crime. The reason, as I said, that we were in this situation is because there is no restraint that compels the government to respect the privacy of Australians. There are vague ideas around it. Politicians pay lip service, but nothing in our laws or our constitution that compel it, and that is why we're in this situation.
Thank you. Next question.
Thank you all for coming. I'm Craig Andrews from the Alliance Against Political Prosecutions. Julian Assange, who you may or may not agree is a journalist, we think he is. He has won awards for this, part of his trade. He exposed war crimes with the terrible video on collateral murder. So my question to Peter and Rawan, what's your organisation's views of the charges of espionage against Julian, noting that the person who leaked the confidential data, then Bradley Manning, has already claimed publicly that Julian had nothing to do with the procurement of the documents. But he's now being facing extradition to the US on charges of, sorry, I shouldn't be reading here, extradition to the US, impact of the conviction worldwide, his ability to report on the US wrongdoing. So he's being charged with, you might help me out here, espionage, I'm sorry. So what is your impression of having a conviction against him and journalists worldwide reporting on US wrongdoing, as he's been denied the protection of the First Amendment, and he's not even a US citizen?
Rawan, can I throw that one to you first?
All I have to say is that our very small organisation doesn't have capacity to campaign for everyone, but of course we support what Julian's work exposed, and we would call on the Australian government to do much more than what they're doing to try and ensure his release. So I'll take it over to Peter to answer.
Right. So let me be absolutely clear. I support Julian Assange, right? I think his incarceration is an abomination. I think that it has gone on far too long. The Prime Minister has previously said it's gone on far too long. It's indisputable that Julian's rights are being violated. You mentioned the First Amendment rights. The First Amendment, for those of you who don't know, in the US, guarantees freedom of speech, freedom of the press, freedom of association, freedom of religion. I think that we can get into technical arguments about whether Julian is or is not a journalist. My own organisation has a particular view on the way that we need to be defining journalists, and we think that actually who is a journalist is not the way to go. We should be defining journalism as a process, and for those reasons we think that Julian falls outside our definition. But I do not want I do not want that to distract from my support for Julian. There is freedom of speech. There is a fundamental freedom of speech right in the First Amendment that I think Julian duly exercised. It is indisputable that the crimes that that WikiLeaks exposed needed to be out there in public. It is indisputable that there was an overriding public good in what he did. It is indisputable that his prosecution sends a chilling message and is a grave injustice. And for those reasons, we are calling for his release.
Yeah, and certainly WikiLeaks is a publisher. I don't know by whose definition, but I'd imagine the New York Times and Guardian, for example, might be in a bit of trouble.
This is the thing and from journalists, whatever we call Julian, and again, we can have a big semantic debate about that, but his prosecution has very serious implications for journalists and journalism. And again, for that reason, we're opposed to it.
And obviously, for those who aren't aware, we recently saw a cross-party delegation travel to the United States to lobby for his release. Next question. Thank you so much.
My name's Lynn Beasley. I have supported Witness K and Bernie Calera for a long time, sent my signature into a lot of things. So I'm very much in favour of whistleblower legislation. However, for the last 2 months, I've been campaigning for the Yes campaign around Canberra. And one of the things that has worried me the most is the amount of misinformation that people have obtained from the media, from Murdoch newspapers and Sky News, and it's been thrown in my face. Luckily, I know enough about the stuff to be able to come back, but once people have taken that in, they're not prepared to let it go. So my question is, how do we put legislation in that supports whistleblowers but calls for truth in reporting?
Great question. Peter, if you could just fix the media industry for us with your answer.
Well, actually, I do have some ideas about this, all right? Forgive me, I feel like I'm dominating the stage here a little. Look, so this comes back to our definition of journalism rather than journalist. The problem, in fact, it's what Brett Walker called, rather astutely once called, the Assange problem, that people tend to define journalists depending on whether they think he is or is not a journalist. And the difficulty is, in the digital world, it's almost impossible to do that in a meaningful way that includes everyone that we need to include in the definition and excludes those who are just sort of chances. So I've decided to take a completely novel approach to this. We've decided that what matters in the news business or in journalism isn't so much what you call yourself, what's on your business card, but it's the role that a particular type of information plays in our democracy. It doesn't matter who is doing it. It's the process that you apply. It's the way in which you gather information, organize it, and present it that constitutes journalism. And in section 126K of the Victorian Evidence Act, there is a definition. It's very simple. It starts the traditional way, which we don't like. A journalist is a person who is in the business or occupation of producing news and information. We don't like that. But then it goes on to say the journalist or publisher shall be accountable, and in brackets, through a complaints process with a recognized code of conduct or set of standards. I think that's the solution. That journalism is a process in which the person that's producing it is accountable to a code of conduct. At the moment, if we put that in law and say that is the thing that we are trying to protect, we're also proposing a professional association of journalism. We think that the current system of industry self-regulation is broken. There is the Press Council and ACMA that both deal with the big institutions. Hands up who knows the Press Council exists or that's a way of making complaints. A few people, a lot of you don't. ACMA is the similar. It has no real respect. It has no real teeth. It is complete. Both of them are completely ineffective. And I can say this because I'm a member of the Press Council. So we think that if we took that definition of journalism as a process, we set up a professional association, a voluntary association that's not a barrier to entry, but journalists could apply to become members of. You demonstrate your capacity. You say you're going to be accountable to a code of conduct. You provide a portfolio of work to show that you know what you're doing. The law then provides top cover to those journalists. If those journalists are accountable as individuals rather than as corporations to the code of conduct, we provide upward pressure on good journalism. Because if you're a member of the association, you get top cover from the law. We provide an incentive to our politicians to introduce a Media Freedom Act with this model, because we're also delivering something that's really, we're delivering a high quality of journalism to our public. Crucially, what we're also doing is badging work that makes the standard. And I think that definition means that we're far more likely to get compliance of individuals to the kind of truth, verifiable truth in journalism that you're talking about. We can't ever eliminate truth, and truth is a very slippery concept if you're really trying to get your hands on it. As a journalist, I can truthfully report a lie that somebody else is saying. Who's responsible? Am I responsible? Well, I am to a certain extent because I have to check the information that I'm broadcasting. But as happened, as we saw in COVID, the truth kept changing.
Yeah.
But this model, I think, could actually solve our problem.
Does the panel mind if we go for maybe 5 more minutes? I can just see 2 questions here. We might get them to ask the questions one after the other. And I'm just going to exercise my prerogative as host to chime in and recommend truth in political advertising laws as a good start for a reform. Currently, it's perfectly legal to lie in a political ad. And the government just so happens to be considering some electoral reforms at the moment. So we'll see where that goes. But I certainly think a push on that front would be good. And just picking up on Peter's point about the responsibility of journalists too, I think we've seen a number of journalists throughout the referendum campaign be concerned about how the media was approaching and dealing with mis and disinformation. And there's also some more legislation that the government is considering that's looking at that as well. And I might just say I recently met Stan Grant, who obviously has raised some concerns about the role of the media in, well, a bunch of things really, but has joined the Constructive Institute, one of which its aims is to promote good journalism by journalists. So you might want to have a look into the Constructive Institute. If I can get you to come and give your question, and then we might get your question straight after. Thank you.
Okay, thank you. My name is Jack, and I've been quite heavily involved in Tasmania with the recent Commission of Inquiry into child sexual abuse in government institutions. And one of the issues that's cropped up for whistleblowers and the victim survivors has been the inability, I think, to permeate the political spectrum, but also the community spectrum. And we often talk about whistleblowers in terms of like big corporations, big government stuff. But I think about my experience in child protection, where I've spoken to children talking about their experiences and their abuse, and actually that whistleblowers themselves can occur within the community. Like they live in your street, they live next door, they may be in your family. And I'm just wondering, in those terms, how can we start to change the language around whistleblowers so that it's not just like the McBrides and the Assanges, but it's actually the people around you to raise that awareness and deliver more social and political action that we actually need to see at state and federal level?
Yeah, fantastic question. Kieran, I'm going to throw that one to you, but if I could get your question, sir.
So my name's Greg Adamson. I'm from Griffith, New South Wales, where I worked as a teacher. It's great to see Peter in person and not in a cage, and it's great that you're doing this advocacy for whistleblowers. My question is very simple. It's just basically, what do you see the role of unions against the institutions? Because they seem to be the forgotten voice in what happens for whistleblowers, and they never seem to be stepping up to the plate to advocate for a whistleblower.
Excellent. Both of those seem like for you, Kieran.
Both of those
Bring
questions.
us home.
To answer the second one first, so we've been very fortunate that the CPSU signed on to our letter to the government in relation to these prosecutions. We've also been engaging with the ACTU. So I think the unions do care about whistleblowing, but part of the problem is that the law doesn't recognise their role. So if you're a whistleblower, you can blow the whistle to me lawfully because I'm a lawyer. You can't blow the whistle lawfully to your union. That's a problem that needs to change. The unions have been pushing for the government to change that. I agree that it would be really fantastic to see the union movement more active in this space, but I think partly that's we need law change to occur as first. I think that's an excellent question. The Commission of Inquiry in Tasmania details horrific wrongdoing, systemic wrongdoing, child abuse in government institutions, called out by brave whistleblowers, but has really not received the attention that it deserves. But I think your question raises this important point of the role that all of us have to support whistleblowers, because so many of us could become whistleblowers, are whistleblowers, and there's this risk of sort of identifying these high-profile cases and attaching to those, but there's so many people in our society who've called out wrongdoing and suffered as a result. For every David McBride, there are 10 people, 100 people under the radar who will never be on the front page, but who are suffering for their truth-telling. And I think it's the responsibility of all of us to play a role in supporting those in our own workplaces, in our own communities when they speak up. Just wanted to end by saying, firstly, really grateful to the Australia Institute, which has been a stalwart supporter of our campaign for stronger whistleblower protections and an end to these prosecutions. So really grateful to all the work the Australia Institute has done. We've done polling with the Australia Institute that shows that Australians want stronger whistleblower protections. They want an end to the prosecution. So that's been really important in our advocacy. I also wanted to say we have a campaign website, droptheprosecutions.org.au. Very simple. The message is very clear, drop the prosecutions. So if you want updates on this work, you can go along there. But I also wanted to encourage all of you. It's so fantastic to see the level of support in this room for truth-telling, for press freedom, for whistleblowing, for transparency and accountability. All of you have a role to play. There's 4 weeks until David McBride goes on trial. I'd really encourage all of you to write to your local member, to write to the Attorney General, to call his office, to write letters to the editor, to attend. So there's going to be a rally outside the ACT Supreme Court. If we don't have an end to the prosecution between now and the 13th of November, there's a rally outside the Supreme Court on Monday, the 13th of November, I think at 9 a.m. So come along to that if you can. It's so important we do all this work. But I promise to end on an optimistic note. I did a lot of campaigning to end the prosecution of Bernard Collaery. At many times I thought that was a hopeless cause. We'd go into court, the court would go into closed session, secrecy upon secrecy upon secrecy. The coalition government did nothing to stop that. It threw millions of dollars at trying to send to jail someone who exposed Australia's horrific conduct, our spying on our neighbour, Timor-Leste. We kept turning up, we kept going to the rallies, we kept writing, we kept giving quotes, we kept advocating, and eventually we won. And I can remember the moment I got the phone call from the ABC saying, the Attorney General has dropped the prosecution, like, what do you have to say? And I'm like, it was a moment of shock. We can have that moment again in these two cases. The discontinuance of these two prosecutions is the vital first step of then a process towards rebuilding transparency and accountability in this country, protecting whistleblowers, building the institutions that protect whistleblowers, integrating that into our wider integrity landscape. We won the campaign once, we can win it again, and I call on all of you to participate in that. Thanks.
Thank you. Another big round of applause for all our panel this evening. Thank you so much, Peter, Rawan and Kieran. We really appreciate your expertise and insight this evening. I want to thank everyone for their amazing and insightful questions. I think we turned up a lot of really interesting angles there. I know you've ended on a really positive note. I did just want to, I'm going to bring the tone down again. I'm sorry. But after the weekend referendum, I did want to finish by thinking about that theme that's come up time and again this evening of truth-telling and how important a process that is, and reflect on some of the key things that the Yes campaign didn't necessarily highlight in its effort to be positive and to reach out a hand to Australia to seek recognition, and that is the number of Aboriginal deaths in custody. There's been hundreds, and as Amy McQuire so eloquently wrote about in the past few years, not a single perpetrator so far. So we've got a long way to go when it comes to truth-telling, and indeed, if we can think of that positive example of you just have to keep fighting and it is possible to change things, I think if anything is a lesson for us all here this evening, it's that we can't give up the fight when it comes to addressing Indigenous disadvantage in this country as well, and it remains unfinished business for all of us. Thanks for indulging me on that one. Thanks so much for coming out this evening. Thank you. We love doing politics in the pub, and we love seeing you all out here. I think it's a really important part of keeping you all involved in our democracy and thinking about the ways that we contribute to it, not just at referendums, not just elections, but in our everyday lives and in our communities and with our networks. And I think coming along to politics in the pub to participate in evenings like this is really part of that. So we really love seeing you all here. What a mammoth turnout tonight. Thank you so much. I have one final plug. Two final plugs. We love Verity Lane Market. And so if you haven't had dinner yet, head on downstairs. It's pretty great. I'm keen to check out the new Korean fried chicken. I haven't tried that one yet. I've been away for a little while. And the Australian Institute next week is hosting the Revenue Summit up at Parliament House. It's on Friday. Basically, we think we need to talk more about revenue. We've got growing public spending needs, whether it's the NDIS, closing the gap, tackling the massive problems with our housing market and the number of people who can't afford decent housing. All of that is going to require more, but we haven't really had a decent discussion about tax reforms. That's what we're doing with a bunch of amazing experts next Friday. And if you check your reminder for Politics in the Pub today, we've got a special discount for all of our wonderful Politics in the Pub supporters to get a discount ticket to that next Friday. It's up at Parliament House. Keynote speakers include Dr. Mike Keating, Professor Patricia Apps. We've got a number of crossbench members coming to a panel, including the ACT Independent Senator David Pocock, and a whole range of other amazing speakers. I'm forgetting someone. Bruce Chapman, architect of Hex, is coming along as well. It should be a really fantastic day, and I'd really encourage you all to come along and be part of that as well. Please make sure you're on our mailing list so that you know about next month's Politics in the Pub. We'll send out information for that when it's ready, and we've got a lot of other amazing events and webinars coming up as well. You can find all of that detail at australiainstitute.org.au. Thank you so much for coming tonight, and thanks for letting us go 5 minutes over time.
Can I just a small plug from me as well? Tomorrow morning at the front lawns outside Parliament House, there'll be a vigil for Gaza, Palestine. So please come along if you have the time. 8 o'clock.
Thanks very much. Thank you, everyone. See you next month.